Yeah, good afternoon, everybody, and possibly, I guess, good morning or good evening, depending on where you are joining us from. I am really delighted to welcome you all to the first of the panels in this BIICL WTO Conference 2020, and this is our first panel after that excellent and very thought-provoking opening address from Sir Francis. So I, as you can probably see on your screen, am Sally Langrish, and I am Legal Director at the UK's Department for International Trade, where I co-lead the legal team. I'm based in London, and that is the focus of our first panel today. The title of our panel is The UK as a Global Economic Actor After Brexit, Rewriting the Avenues for Trade, and we're going to be looking at the UK's trade relationships after Brexit, EU exit. We come to the end of the transition period in 70 days. I counted up this morning, so it's not far away. And that huge transition has obviously been made even more complex and challenging because of the COVID pandemic. So that's obviously, those are matters which we obviously spend all of our time in international trade thinking about in our department. But today I am delighted I can sit back and relax because we have three fantastic speakers who are going to tell us all about it and give their perspectives. So first up, we will have Jessica Gladstone. Jessica is a partner at Clifford Chance, and she's a specialist in public international law, including trade and international arbitration. And she has frontline international relations experience as a former Foreign Office lawyer as well. And she's going to be talking to us about the UK's future relationship with the EU and telling us about the state of the negotiations, which is very topical. So good luck with that. And then we go to Daniel Crosby, who is the managing partner at King & Spalding in Geneva, though I believe he joins us from Washington today. So welcome. And he has deep expertise in all aspects of international trade law and an interest really in the geopolitics of trade. And he's going to be focusing on the UK's future relationships with third countries, and I believe looking particularly at our relationships through the WTO. And then we will be hearing from Isabel, Dr. Isabel van Dam, who is counsel at Van Bael and Bellis in Brussels. And she is very eminent as a trade lawyer and also as an EU lawyer. And she has two topics to talk to us about, a hard task. So she's going to go through the UK's future approach to subsidies and state aid. And then we also hope that there will be time for her to talk to us about foreign direct investment and the trend towards increased screening of those activities. So each of the panelists is going to take about 10 minutes, and we hope that that will leave plenty of time for questions at the end. Please do put your questions into the Q&A function. I believe that's been explained to you all, and you can upvote questions, and we will do our best to take as many of those questions, and starting with the most popular ones at the end. I hope that's all clear, and I shall sit back now and over to you, Jessica.
Thank you, Sally, and thanks so much to BIICL as well for convening this conference and the discussion. I should start with a disclaimer, which is that because Clifford Chance is instructed to advise on the UK-EU deal and the continuity agreements with third states, I should just clarify up front, I'm speaking only from information available in the public domain. Sally mentioned that I would give you an update on the current status of the negotiations, which is no easy task given that they've probably changed since this conference began an hour ago. So with that knowledge, I won't dwell too much on exactly where we're at and exactly how things might be progressing. But the important thing is that despite the tough rhetoric recently, the parties are still talking. And in terms of timing, while we're genuinely running short of time now, pushing it to the wire, that is actually par for the course in many negotiations. Taking a step back, one does expect to fill the time available if there's still issues that might be adapted or changed to, if there's another different form of compromise, a better form of compromise to be reached, it's natural to take all the time that could possibly be squeezed out of a time frame to be able to reach that decision and make it the best one that it can be. And as we'll all recall, of course, the talks on the withdrawal agreement went to the 11th hour also. So in a sense, it's not a surprise that we've passed the deadlines that had been set. I mean, the EU has said the next deadline, I suppose, is that the agreement needs to be reached by the end of October in order to allow time for ratification by the end of the year. Now, ideally, an agreed legal text would have been ready at the beginning of October to make time for legal and linguistic revisions and to build a little bit more flex in the system for that process. We know, of course, that the UK had set the deadline of the 15th of October. That would have allowed political approval from the EU heads of state and government at the European Council meeting that had been scheduled for the 15th and 16th of October. However, as has happened previously in the Brexit process, an additional EU leaders summit could be called to approve a deal. And so realistically, there's another few weeks to finalise a deal and still just creep over the line before the 31st of December is out. It's obviously not an easy negotiation. I don't think anybody really expected it ever to be so. This deal obviously has to support every aspect of the two economies, taking into account the interests of producers and consumers, and trying to future-proof for a trade landscape that's evolving in a serious way on an ongoing basis. And this future-proofing is an important element. Trade issues are not frozen in time, they keep changing, which is why the title of this panel is so appropriate. The avenues for trade really do still need to be written and rewritten. And this is as much about the global context as about Brexit, in fact. The global context in which this negotiation takes place is really important to understanding what it needs to achieve for the success for the EU and the UK going forward. For example, we'll take three, but there are many, tech developments. Digital trade and e-commerce are becoming increasingly important, and that's only accelerated because of COVID and the response of business and of lifestyles to COVID and what needs to happen to accommodate this dramatic change in the environment that we operate in. Another example are ESG values, environmental, social, and governance values, which are taking a centre stage in trade deals more recently. And this is because they can help establish a level playing field for countries who are imposing more exacting standards on their own producers. Typically, they cover labour, environment, perhaps gender equality, human rights, Indigenous and Aboriginal people's rights, corruption. These sorts of issues might be anticipated as wrapped up in the sorts of values that can be elevated to the level of a trade deal. And for example, we have seen in the USMCA a corporate social responsibility subheading within the investment chapter, whereby the voluntary standards imposed, well, not imposed, that's the thing, but there for businesses to sign up to and to adopt are elevated to that level of international law and recognition in the trade deal. And more recently, even just the other week, the EU proposed a gender chapter for their FTAs going forwards, recognising the significance of that issue for international trade. So lots of change in that sort of field. Also, trade and climate change, and using trade deals to help achieve the objectives of carbon neutral targets within the next 30 years or so. And so this is either removing tariffs on certain goods and harmonizing standards on environmental services, for example, eliminating subsidies on fossil fuels and agriculture. These sorts of trade policies can be incorporated in trade deals also, and we're seeing that at an increasingly going forward. So there's a lot of different issues that are coming to the fore in the modern world that make trade deals even more complicated than they always were. And that's not to understate how complicated they were even even a few years back. And so bringing us to some of the key issues that are left to resolve between the UK and the EU, one of them we know is this very fact of the level playing field. The EU has said that it won't agree a deal unless the UK agrees to enforceable common standards on state aid, on subsidies, but also workers' rights and environmental protection, in order to create that level playing field for open and fair competition. And that's been their position on that. Another big issue where a compromise will need to be reached in order for a deal to be finalised is in fisheries, where the EU is also looking for an agreement on fisheries which would provide continuity in EU access to UK waters. We know that other key points of contention have been in terms of cooperation between police and judiciary in criminal matters, and also just the very governance of the future relationship. And this has been a really important one in terms of the structure of the agreement, so the treaty architecture, how many parts it comes in, the institutional setup and oversight, and also critically on how dispute resolution between the parties will work in the future and the role of the Court of Justice of the EU. So these are, and the latter being obviously a particular issue for the individual relationship between the UK and the EU. But as I say, set in this global context where so much is changing and so much needs to be considered and addressed in trying to make an environment for trade going forward that really works for business and really works for the economy throughout the countries involved. As if it wasn't complicated enough, there are of course other issues too, which you might not be the focus of the trade deal, but which need to be resolved in order to enable free flows of trade from the 1st of January onwards. And one crucial issue is that of data sharing. And this has been complicated by the decision in Schrems from the Court of Justice of the EU in July, annulling the US-EU privacy shield and casting doubt over whether standard contract clauses approved by the European Commission can actually be relied upon for lawful data transfers. And as e-commerce becomes increasingly important, data flows are a major factor for fluid trade flows going forward. And so resolution of these issues beyond the four walls of the trade deal are also vital for business and trade to flourish in the new environment. Finally, I'd add that no trade agreement, of course, is taken in isolation. What is agreed with the EU will have knock-on effects on the UK's other trade deals. And of course, the UK is very busy simultaneously now working to secure rollover deals for the agreements that the EU already had in place with third countries to replicate those and get those in place for the 1st of January. There's more than 70 countries involved in those rollover agreements. And so there's a lot of work to be done, although much has already been secured and delivered. And I know a lot of hard work is happening to complete more before that deadline. Of course, some of the issues that will arise and that need to be considered in terms of the read across between this deal and others come up with the rules of origin and the complications there, where the UK will want to have flexibility around, given their complex supply chains that exist, some flexibility around how much needs to be produced in the UK in a formal sense, how much parts of a product can have been produced elsewhere and still be classified as UK goods for the purpose of taking advantage of the terms that are being negotiated and the preferential tariffs that will be secured in any deal. And also issues of most favoured nation as another example of the read across between trade deals that, as I say, just make it even more complicated than it might have been otherwise. And given the current crisis in the WTO, which the UK also intends to play a significant part in resolving, and Daniel will speak more about the WTO in a moment, but bilateral and plurilateral deals are going to be more important for the time being than anything developed multilaterally at the WTO. And so this programme, the UK's negotiations with the EU, with the rollover deals, and also with the US, Australia, New Zealand, and its stated intention to accede to the TPP or TPP-11, these become really important pieces in the jigsaw puzzle for its future role as an economic actor in today's very changing, very dynamic world. I'll stop there for now and pass back to you, Sally.
Thank you, Jessica. Beautifully to time, and that was a great roundup of stuff that certainly I and a few of my colleagues, who I think I can see in the participants list, are pretty familiar with. So thank you for that. Daniel, over to you.
Thank you very much, Sally, and good morning from Washington. So I'd like to pick up on a point that that Jessica made, or a kind of statement that she made about the title of our session, and key off that about global avenues for trade still needing to be written and rewritten. And of course, when you have Brexit going on, and as Jessica has explained, you know, there's a lot going on, both in the bilateral context with the EU and with all FTAs, and you're basically the entire world of trade. At that time, it was hoped that there would be this WTO option that was the safe haven, and I think what Jessica was saying at the beginning and the end of her presentation, I will start with that this safe haven of the WTO. I mean, legally, of course, it's there's a WTO option. Practically, there's a lot of work to be done to get the WTO into shape, where it's going to have to advance the interests of the UK on a global scale. Other panels will talk to some details of that, but following Jessica's presentation, I thought hard about trying to give some good news about this WTO backstop, and I thought about discussing trade beyond the difficulties of discussions with the EU, of which there are some. And I wanted to base my discussion on this time-tested, kind of rules-based international trading system that has served the UK and everyone else so well, that has always provided certainty and continuity in times of economic turbulence, and that the UK itself was instrumental in negotiating and creating nearly 75 years ago, based on the very British principles of free trade and market-based economics, and all these things are very close to home for you all in the UK. But at the same time, excuse me, I can't claim to be a bearer of very good news today along those lines, and rather more realistically, I'd like to share a few observations and frame some questions about the UK's future relationship with third countries, mostly focusing on the WTO, but applying the principles also to bilateral trade. And I'd also like to point out a fairly unique British comparative advantage in this context that's often overlooked. So first, I think not just the Brexit relationships, but all relationships of trade are being recast because of this general reinvention of the multilateral trading system that will be implemented, I believe, over the coming months and years. So this idea that the global avenues need to be written and rewritten is actual in my view, and will be really launched in earnest hopefully next year, but needs to happen, and we can't exist in the current system. So just in time for Brexit, the WTO, as we've known and loved it, is severely crippled, mainly I think because the MFN principle has played out its useful life. WTO members seem not to share the same goals and operating principles, and therefore try and find groups of countries that want the same things in bilateral, plurilateral, other kind of groupings within the WTO, but just not MFN. This would suggest that it is a good time for FTAs in exploring new rules. And Jessica was mentioning some of the FTA structures that are evolving with third countries. I think the negotiation of those is difficult, but the structure is not that complicated. There are some new issues that were mentioned, and I'll talk about as well. But the basic point that I'd like to make is that whatever avenue you choose, there has to be an underlying principle there. So I'll leave some of the details to the kind of future of the WTO and topics to other panels that I know are coming, and I'll focus on the big picture of how the UK can recast its trade relationships in light of the ESG principles that Jessica mentioned, in light of its own economic, political, security, sustainable development, all these things. But based on the question of whether, in all that mix, whether principles matter or just trade outcomes in the context of trade relationships and negotiations. And if principles do matter, which principles matter and why? So when considering trade relations, does the UK need to consider the economic implications of the absence of those principles or their lack of enforcement to assure that the value of the deal comes through in the end? So you may have seen that the G20 just completed a useful exercise relevant to this point. And in a communique issued last month, G20 ministers helpfully listed fundamental trade principles that they all agree on, which is great in this day and age. All G20 trade and investment ministers, including the UK's Secretary of State for International Trade, Elizabeth Truss, not only reconfirmed that the rule of law matters to trade relations, but they listed it as the very first item on their list of common foundational principles for WTO trade relations. And the only thing I'm going to share real quick with you, so you see what I mean, this is the front page of the communique from just a month ago, exactly. And in this summary of the document prepared by the chair of the Trade and Investment Working Group, the goal is to provide support to advance necessary reform negotiations in Geneva. So in order to do that, they looked at common objectives and foundational principles. And here you'll see all members agreed to this list. It starts with the rule of law. There's not a huge discussion of what that means, which I think is the starting off point that we have in negotiations, but this frames the important issues. Transparency is part of rule of law. Judicial independence is a black letter, old GATT concept, rule of law. But of course, these are not really enforced, and some seen as not enforceable. And I'll talk a little bit about why that's a problem. So I guess my main point is that many of these principles, including those related to the rule of law and the rule of law itself, without them, there would be no foundation for trade agreements, and we can't have a secure trading avenue that we can depend on. So I decided to focus on the rule of law here for two reasons. First, because of the relative strength of the rule of law applied by your trading partners will determine the value of trade agreements to the UK. And second, because the UK has a strong economic interest in the rule of law based trading system just because of your position in the world, as well as a clear comparative advantage in understanding, applying, and teaching about the rule of law. In my view, UK interests would be well served by confirming at every opportunity that the rule of law has a direct effect on the value of trade agreements. So the value of trade agreements should be evaluated based on the prevalence of the rule of law in your various trading partners. Now, in particular, given the context of our conference, I have to note that the organizers, in particular BIICL's Bingham Center for the Rule of Law, are world leaders in this area. In the context of the G20 work and everything that was going on this year, I was actually rereading Bingham's seminal book entitled The Rule of Law, which was just printed 10 years ago. Unfortunately, God rest his soul, just a few months before his death. But he did succeed in a whole career of law in the UK, founding the Bingham Center on the Rule of Law, and getting this great book out, which we're still using today. So the namesake of your center, who was organizing this conference, Lord Chief Justice Bingham, stressed the importance of the rule of law for trade and economic development, both domestically and internationally. He even cited the GATT as part of the rule of law foundation for international economic stability in his book on the rule of law. In the context of today's unilateralism, it is interesting to recall his very basic rule of law point that the acceptance of constraints is the necessary price to be paid for their observance by others. And in the international context, he cautioned that however attractive it might be for a single state to be free of the legal constraints that bind all other states, those states are unlikely to tolerate such a situation for very long. And in the meantime, the solo state would lose the benefits and protections that international agreement can confer. And this goes, and this is a 175-page book, and it goes into exactly why all that matters. So I'll wrap up with the recognition that many rule of law principles are a bit aspirational and are difficult to convert and distill into treaty text. But there seems to be a growing recognition that principles matter, from the ESG principles that Jessica mentioned, trade and environment, trade and labor. All these things are coming in to all trade agreements, and that's unavoidable. There seems to be a growing recognition that principles matter legally, economically, socially, to trade relations, and that more work needs to be done to understand the concepts and to assign specific economic value to the rule of law provisions in treaties, so we know where to focus negotiations and how to enforce rule of law obligations and provisions. What are we going to do when our trading partners don't respect the rule of law? It is understandable why the UK and other countries sometimes seem to take the rule of law for granted as the foundation of bilateral and multilateral trade relations. The rule of law is just there in the UK. But if we scratch the surface, we quickly see that the understanding of and commitment to the rule of law in trade relations with third countries is sketchy at best and strategically exploited in the worst cases with unchecked power, corruption, and other abuses of rules and the rule of law. So as we keep rewriting the avenues for trade, I really hope that the UK plays its traditional British role of pointing to these principles and coming up with concrete provisions to identify and enforce them, and that we don't think of the rule of law and these principles as just big principles, kind of pie in the sky, stretch issues, but those issues that are absolutely essential for our businesses, without which they cannot conduct economic activity and trade. So we need to convert these big ideas into treaty texts that have meaning and that are enforceable. So with all of the particulars going on of, negotiating points and you give me fish for steel and all these other things that negotiators have to deal with, I wanted to take a minute to just step back and address that point because of its specific relevance to all the negotiations that are going on, to its particularly British character, and I guess to kind of hats off to the UK for its kind of 800 years of development of the rule of law. Anyway, thank you very much, and I look forward to questions.
Thank you. I'm hoping you can hear me. My microphone's doing something funny. Thank you, Daniel, for that excellent sort of big picture stuff, and then bringing it down into our sort of day-to-day practice and the exhortations to those of us in the UK. Isabel, over to you now. The floor is yours.
Thank you very much, Sally, and thank you to the British Institute for organizing this year's edition of the conference. So, as Daniel already mentioned, the multilateral regulation of trade is changing and is facing uncertain times, and many WTO members, including the European Union, are seeking to sharpen their trade policies and their case to set the terms of trade. And COVID-19 has only accelerated these developments. And amid this disorder, the United Kingdom is reclaiming its autonomy in trade policy. So as Sally mentioned, I'll focus on subsidies, and I doubt there'll be any time left to deal also with FDI control. But in discussing subsidies, I'll make a distinction between first, the internal regulation of subsidies, and especially domestic subsidies. Second, the multilateral regulation of trade on subsidies. And third of all, the increasing unilateral and plurilateral initiatives to address perceived gaps in those multilateral rules. So my first point is that the United Kingdom has not yet settled the issue of if, and if so, how, it will design an administrative process starting from 2021 for controlling public spending and for assessing its assortive effects on its internal market. We know that current public spending is still governed by EU state aid rules until the end of the year. And for public spending that affects trade between the European Union and Northern Ireland, that spending will also fall within the scope of EU state aid rules after the end of this year by virtue of Article 10 of the Northern Ireland Protocol. And the extent to which Section 45 of the draft Internal Market Bill empowers the government to depart from Article 10 of the Northern Ireland Protocol has already been subject to wide public scrutiny in the United Kingdom, as was already discussed by Sir Francis in his keynote address. Now, the fact that the government states that it will follow WTO rules does not really resolve the issue, because the SCM agreement addresses responses of other WTO members to UK subsidies. And the SCM agreement also does not deal with subsidies in respect of trade and services. It seems that the sole fact that the European Union has a very intense state aid control regime is an insufficient reason to dismiss the need for a proper debate about whether or not it's preferable for the United Kingdom to taking into account its internal market and its powers of its devolved governments to develop a control regime and to decide on the structure and design of that regime. Engaging in that debate seems to be an imperative, regardless of the state of the negotiations between the European Union and the United Kingdom. And that debate entails addressing questions such as, for example, what is the risk of interstate subsidy races, the possible form of control, the involvement of an independent regulator, whether that be the CMA or another authority, the application of the specificity criterion in respect of regional aid, the de minimis threshold, the standard of injury, and the available remedies. And I would say that answering those questions does not necessarily imply a binary choice of yes or no adopting EU state aid rules. In fact, it could be argued that whatever the approach to be taken by the United Kingdom in the negotiations with the European Union, that approach should be a consequence of the conclusions reached on the costs and benefits of installing a state aid regime in the United Kingdom. But at present, that doesn't appear to be the case. It seems that it's the government's negotiating strategy in the EU-UK negotiations that controls the debate. And it might be a lost opportunity to dismiss the merits of an independent UK state aid regime for the sole reason that the European Union insists on the United Kingdom having one as an essential level playing field condition for obtaining market access under a future free trade agreement, as Jessica explained. The second point I'd like to make is that if the United Kingdom opts out of putting into place a state aid control regime, and perhaps even doesn't conclude an FTA with the European Union, then the SCM agreement and domestic implementing legislation will indeed dictate the terms according to which the United Kingdom can respond to subsidies conferred by other WTO members, including the European Union. However, the SCM agreement is unlikely to define exhaustively the types of responses from other WTO members, including the European Union, to UK subsidies. And putting aside an eventual reform of the SCM agreement in response to concerns with respect to especially China's public spending, the fact is that especially the European Union is seeking to widen the tools available in order to respond to subsidies granted by foreign governments. And that decision stems from the European Commission's assessment that the SCM agreement is incomplete and inadequate. And the audience of this conference will, of course, already be well familiar with the Commission's white paper on foreign subsidies. That white paper puts forward a new toolbox organized around 3 modules. A first module dealing with the distortive effects of foreign subsidies in general, which would involve an ex post assessment. The second modality being domestic foreign subsidies causing distortive effects in case of acquisitions of EU assets, which would involve an ex ante assessment. And then harmful effects of foreign subsidies on access to EU funding and EU public procurement. And each of these modules envisages that the Commission and possibly the authorities of the member states are given far-reaching powers in investigating and making a determination of the impact of foreign subsidies on the right to operate in the internal market. Now, the premise of the white paper is that, as things stand, economic operators benefiting from foreign subsidies largely fall outside the current regulatory framework that applies to similarly placed economic operators benefiting from funds of EU origin. And by insisting on the need to level the playing field, the Commission is in essence stating that such operators are in a similar situation and thus should be subject to similar scrutiny. And there are many legitimate questions to be raised in respect of these proposals. We could discuss, for example, whether in fact these rules do not treat rather differently and more strictly economic operators receiving funds of foreign origin. We could also debate whether the SCM agreement at all applies, and whether in particular Article 32.1 of the SCM agreement should be interpreted as precluding a WTO member from taking action against a covered subsidy in circumstances where even the SCM agreement itself does not make available a remedy for responding to such a subsidy. Other questions relate to whether some of the proposed measures, including the remedies, are a violation of the EU's WTO obligations under, for example, the GATS, the TRIMS agreement, or the TRIPS agreement, but also possibly under investment agreements, if those agreements protect also the admission to investment. Still, another question is whether the current EU state aid control regime and merger control regime can in fact be applied by analogy to foreign subsidies, subject to a few adjustments. And then a final question perhaps is, what is the cost to be borne by economic operators who will need to comply with far-reaching notification requirements and become subject to broad discretionary powers in respect of all economic activities, having benefit directly or indirectly of foreign subsidies. Now, all of those questions are closely related to the protection of the United Kingdom's defensive interests in trade. And in any event, regardless of the responses to these questions, what matters is that guaranteeing the level playing field will be an issue in the EU-UK relationship, even if no FTA is concluded between those parties. In particular, if the modules put forward in this white paper result in concrete legislation, it will mean that the European Union can directly or indirectly scrutinize UK public funding having distortive effects on the internal market. And even if an FTA is concluded, the Commission currently envisages that UK foreign subsidies could be addressed both under the FTA rules governing subsidies, but also under these new sets of policy instruments that the Commission envisages. My third point is that putting aside the European Union's unilateral initiatives, other WTO members are also concerned about gaps in the SCM agreement. And an expression of that assessment can be found in the January 2020 joint statement of the European Union, the United States, and Japan. And that statement calls notably for more strict control for subsidies, a longer list of prohibited subsidies, increased transparency, and a revisited understanding of the concept of public body. And such initiatives signal that the landscape in respect of various controls on subsidies, and thus also on industrial policies, is changing. And for the United Kingdom to become an important stakeholder in those debates, it must define its policy on subsidies control. And merely confirming the application of the SCM agreement is not sufficient for that purpose. My final point is that I understand that the United Kingdom is currently proposing to the European Union to include provisions on subsidies that will be familiar or similar, sorry, to the EU-Japan EPA provisions on subsidies, and that have also been, we understand, transposed to the UK-Japan agreement. And similar to Jessica's point, it might be that this actually point of my presentation is already outdated in light of current developments. But the EU-Japan EPA, in essence, contains new reciprocal obligations in respect of specific types of prohibited aid. And it relates to public spending for economic activities, both in the areas of trade in goods and services. However, it does not require either party to implement a mechanism of ex-ante control by an independent regulator. Instead, certain specific subsidies are prohibited subject to the general exception clause in Article 20 of the GATS or Article 14 in the GATS. Now, this set of treaty rules or this model can be contrasted with other models. One is the EU-Ukraine Association Agreement, where Ukraine indeed accepted the commitment to introduce a domestic state aid control regime. Another example is Chapter 7 of CETA, which doesn't really focus on substantive provisions in respect of subsidies, but is more focused on further developed process-based obligations going beyond the SCM agreement. And in essence, there are two general models. There's the WTO plus approach in the EU's FTAs, and there's a state aid approach. But we might need to look for another variation or another approach to meet the interests of both the European Union and the United Kingdom in these negotiations. So in some kind of the risk to which the United Kingdom will become subject after the end of this year and in the years to come is certainly EU countervailing duties, EU litigation before the WTO, possibly under the withdrawal agreement, but also an FTA, but also unilateral responses to UK subsidies distorting the EU internal market, and increased restrictions on access to acquiring EU assets. And that risk assessment must also take into account that some of the initiatives that might be developed in particular to respond to concerns about China will of course have to be applied also to other preferred trading partners in order to avoid any impression of discrimination. So I conclude that at a time of reclaiming its autonomy in trade policy, careful balancing is needed in the United Kingdom's offensive and defensive interests in trade. However, that presupposes that those interests have been defined. And it seems to me that in the context of subsidies, that definition and thus that element of its industrial policy is still lacking. Thank you for your attention, and I look forward to our discussion.
Great. Thank you very much, Isabel, for that expert critique. And yes, I noticed you didn't manage to get onto your second question. So if people have got questions about FDI, then maybe put them in the question function, and maybe we can take that. Maybe we can take that as part of the questions. So we've got a couple of questions already coming in the Q&A, but I would invite the audience participants to put any other questions they have. Ah, no, there are more now. I scroll down. So anyway, let us start at the top on a first come first serve basis, and we'll take a question from Eric White, who says, "What are the prospects for an early harvest of what has been agreed, presumably with the EU, while continuing to negotiate on the rest?" Jessica, would you like to go on first on that?
Sure. So I guess the challenge is what twofold. One is what are the parties prepared to agree to? Because so often with trade agreements, what you are trading against comes in different chapters of a trade agreement. So finalizing one when you are still, where the interests favor one party, where you would want to trade that against perhaps a different chapter or different issues, then you don't want to do part until you've done the whole. So there's that sort of restriction. The second restriction is the WTO Mfn rule, which is that the most favored nation requires that a comprehensive agreement is done that affects substantially all trade, in order that preferential treatment can be given to one counterparty and not to everybody else in the WTO. And so these are the sorts of restrictions then that will be in mind as the negotiations continue. But that said, then, you know, there are structurally different ways of going about this. And if the parties are willing, it could well be possible to do some parts of a deal without concluding absolutely everything, if the limitations and restrictions I've just been spoken to have been taken into account.
Thank you. Would either of our other panelists like to comment also on that question? No, they're not jumping in. So I'm going to look in the question bar and choose another one. Okay. So James Flett has a question for Daniel in the first instance, though I'm sure others may want to comment. And he says, on what terms should a hypothetical Biden administration return the US to a WTO rule of law dispute settlement system by unblocking appellate body appointments? If treaty changes are required but can't be agreed, absent consensus, does that mean the US will remain outside the rules-based multilateral system? Over to you, Daniel.
I expect nothing less from James Flett. I think on the issue of hypothetical administrations, I think I'm in, of course, I think we're 12 days out. I have no inside view of what a Biden administration would do at all, and don't speak for them. So I just purely hypothetically, if the Trump administration or a new administration wanted to, as James says, return the US to the WTO rule of law dispute settlement system, then of course it could unblock the appointment of appellate body members. And I think we'll hear about that in the following panels. There was another question that I saw that I'll lump into the next part of the answer of if the UK has a certain withdrawal agreement and legislation, does that mean if the UK can't play its traditional role in the rule of law? Or here, if the United States or any other country doesn't like something about a treaty and doesn't abide by a provision or follows the procedures to block rules or blocks consensus, which is one of the main problems of WTO governance is this idea of consensus, that if one country doesn't like a certain provision, they can disagree, which then blocks progress in many situations. I don't believe that means, such blockage means that the blocking country rests outside the system of the rule of law. And in this case, I think countries express displeasure and lack of responses to their displeasure through such procedural mechanisms, and I think that's what we have now. I think generally the quote that I read from Lord Bingham about the solo country wanting to go on its own, I think the eventually part comes back now, that eventually other countries won't like that very much. So when the pressure is turned up, then we have a negotiation, and that I don't think we can equate the WTO and its system with rule of law in every sense domestically. In fact, when Lord Bingham starts his chapter on international law, he kind of says that this reference to the law of nations is even, I think he uses the word pernicious, that the rule of law has to start at home. And that's why a withdrawal agreement, as long as it's consistent with the kind of basic provisions of the rule of law, and if the United States blockage is consistent with WTO rules, you can argue as you want about the spirit, but the rules are there, and I think the UK and the United States are following them to the displeasure of others in some cases, but that doesn't mean they're outside the system of the rule of law.
Thank you. Would either of our other panelists like to come in on that? Isabel?
Yeah, I'd just like to point out that I think that the developments in the WTO during the past few years have taught us that we thought that there was very little option for veto rights in the operation of the WTO dispute settlement, because at significant stages we had the reverse consensus rule. And we've now discovered that there are actually still a lot of gaps in the DSU where there is a possibility for exercising a veto, as we've seen during the past few years. And there, I think it's just helpful to look at what's happening in the FTAs, because what you see in the dispute settlement chapters of the FTAs, and especially the ones negotiated by the European Union, is that in those chapters, the European Union is seeking to exclude those risks. So in thinking about how to change the rules in the WTO, we'll certainly have to learn from the practice under the FTAs. Thank you.
Thank you. Let's stick with rule of law for the moment, because there are quite a lot of questions in the chat about this, not surprisingly. We have a question from Wolfgang Weiss, who says, Daniel, and potentially Jessica Isabel too, thanks for confirming importance of rule of law, but how does this combine with hesitance regarding effective enforcement that we might observe from the US, but maybe also from the UK? It's a question sort of on a similar theme, but if you'd like to expand, then please do.
Thanks for that. And I saw Mr. Weiss's question there. And one of the things he also mentions is that G20 statements appear as lip service. And I would say that's a kind of generally fair assessment from the outside. But I would also say that these statements are what you do with them. And, you know, these big statements are intended to be applied. And so countries use each other's statements in bilateral and multilateral settings to hold countries to account for what their ministers and leaders have said. And so this statement that I showed on my screen was submitted to the WTO, to all members, was presented at the General Council, and it was mentioned, the principles in that document were mentioned by many ambassadors in the first General Council meeting following its issuance, and now there's a debate going on. And that's what it's supposed to do. That is the role of these organizations. So sometimes the words are a bit empty, and then sometimes not much is done with them. But for example, the UK could take this rule of law G20 statement that it supported, and as I mentioned, the rule of law is not defined or elaborated on at all in that document. It seems like a good opportunity for a country like the UK to play its role at the WTO and put more meat on those bones. And that's the kind of thing that I think would be helpful for the UK when it starts taking up its individual role at the WTO. That's the kind of thing that could be there. Very quickly on the point of effective judicial arbitral enforcement, I think that when a system of law is not functioning and a country is bound by that system, which it considers to not consistent with its sovereign agreement, then it either has to renegotiate, withdraw, or use the procedural mechanisms within the system to achieve change and leverage. And I think that's what's going on. It's not that somebody's going to magically flip the light back on and all of a sudden the system's going to function. I think there was always a risk and a fear that by caving in to U.S. demands, then it would look like we're not having the rule of law, because it's this power play, and that's part of preserving the rule of law, is not caving into such pressure, but where the rules really do need to change. And the only way to change them is to achieve consensus. And we can't achieve consensus, but you still feel that your sovereign rights are being denied. I mean, you can spin your wheels forever in that debate, but the United States decided to stop spinning. And so I think that's not an issue of long term. It will be an issue of rule of law if we don't have dispute settlement. Dispute settlement is absolutely, and respect for international law is a principle of rule of law, according to Lord Bingham and everybody else. So we need to get back to that, and I think we will, regardless of the next administration that comes in the United States in 12 days decision.
Thank you. Isabel, I wondered if you might like to comment on the rule of law in your particular areas of subsidies, or maybe even anti-dumping. We have some big states there who take a particular approach to the law. What would you say?
Well, I think it's especially a debate that's currently happening in the United Kingdom on the question of whether or not there should be an independent regulator of controlling domestic public spending, rather than it being a type of political control. So I think that debate is particularly visible in the United Kingdom in the area of subsidies. And I understand that in the context of the discussions currently in Parliament, that question is also being considered, and whether, if there is to be an independent authority, who should it be, and what would then be the remedies available. Of course, if it is a question that is fully within the discretion of the government, then arguably such remedies won't be available. And that's of considerable concern, one can understand, for the European Union, but for a lot of other trading partners of the United Kingdom equally. Thank you.
Thank you. Jessica, would you like to come in on this?
I suppose it's obviously a very interesting line of thought and of questioning, and quite an appropriate one. I think it's a very, for all the reasons that Daniel was saying, obviously the rule of law is crucial to the proper working and the long-term success of our interactions internationally, as well as obviously within a domestic setting. But I would say I take heart from the fact that in all the dialogue and discussion around the crisis in the WTO, or developments in the US or the UK or elsewhere, that actually the measure by which this is regarded, the lens through which the commentary runs, is that of the rule of law. And while that is a measure that is internationally recognized and something, albeit not perfectly defined, as Daniel also said, we do have a sense of what it looks like and feels like, and that is a measure by which the whole debate is governed. And I think that that's a very useful sign that the rule of law is alive and well, and we will be able to continue to use our every effort to align ourselves with that ideal and with that principle in terms of how everything actually works in practice.
Thank you for that very sort of hopeful note there. Yeah, I trust it may be the case. I'm going to lastly go, I think, to Isabel and pick up Eric's question, coming back to subsidies. And he says, do you consider the envisaged EU Module 1, control of foreign subsidies, may not be compatible with Article 32.1 SCM, where the SCM doesn't contain a remedy that the EU considers satisfactory? Quite a pointed question there, so take it away.
Thank you. And thank you, Eric, for raising the question. So just to remind everyone, Article 32.1 of the SCM agreement, what it actually states, it says that no specific action against the subsidy of another member can be taken except in accordance with the provisions of the GATT as interpreted by this agreement, the SCM agreement. So in essence, there's two separate questions that arise in order to address Eric's question. The first is whether or not a foreign subsidy is covered under Article 1 and 2 in the way that the European Union envisages Module 1. And there are debates in terms of the extent to which Article 1 and 2 apply. And of course, we know that Article 1 and 2 in any event deal with goods and not services. So if the kind of foreign subsidies types of measure that the European Union envisages, the point is if it's not covered really by the SCM agreement, then there's also no remedy envisaged by the SCM agreement. And if there is, the foreign subsidies is covered in that way by the SCM agreement, then the fact seems to be that there is no specific remedy that is envisaged in the SCM agreement. I think it's only when you accept that this type of subsidy is covered by the SCM agreement that then Article 32.1 kind of kicks into action and applies and precludes then the use of a remedy that's not envisaged in the SCM agreement. If you, of course, say that the subsidy is not covered by the SCM agreement at all, which seems to be the argument of the European Union, saying that there is a gap in the system, then, of course, it's more difficult to assess whether or not Article 32 actually precludes the European Union from adopting these measures. And there, I think there's much more debate to say that if the agreement wasn't intended to cover this particular kind of subsidy, then it's logical it doesn't also cover any particular remedy, so that there's still some freedom for WTO members to act based on the agreement as it currently stands. But that wouldn't actually mean that there's no WTO problem. As I said, there are a lot of different types of remedies that are put forward in the white paper. And those remedies could entail measures that fall within the scope of the GATS, the TRIPS agreement, the TRIMS agreement. So it's a problem that needs to be considered not only within the perspective of the SCM agreement, I would say. Thank you.
Great, thank you, Isabel. We're just after 2 o'clock, so we need to begin to wrap up this panel and give everybody a little break before the Geneva panel, which will be starting at 2:15. Just looking, I hope others in the chat will forgive us for not picking up all their questions. To Naina, I think your questions may also be picked up in the Geneva panel. Well, there's a panel on dispute settlement tomorrow morning, which I'm sure you will be delighted to answer your question. And to Wolfgang, very quickly, I wasn't going to answer any questions actually as chair, but I will tell you, Wolfgang, that you can look on the gov.uk website under Department for International Trade. And I hope there you will discover publicly available information on how many bilateral free trade agreements the government has now got in place through our department working with the Foreign Office. And we have about 20 agreements signed, many of them going through or have reached ratification, and that covers about 50 countries. And you can find information on the programme there and how we're doing. So the answer is we are doing quite well, actually. Not to gloat, but yeah, we're getting there. This just remains for me to sort of thank our panelists. I hope you enjoyed their contributions. Personally, I found them incredibly varied and sort of thought-provoking and stretching. So thank you for joining us for this panel, and we hope you enjoy the rest of the afternoon and the rest of the conference. Thank you.
Thank you.